Thank you. Yes, Mr. Chairman.
Good afternoon, my lords. I unsurprisingly adopt the submissions that the court have heard on behalf of the first respondent, and I don't repeat those. And in light of those submissions, there are just 5 short topics that I would seek to assist the court with, and I can deal with them, I hope, shortly. The first, my lord, is just a factual point that was raised during the course of the first respondent's submissions before lunch. Need had been a policy requirement in terms of proposals for out-of-centre or edge-of-centre retail development, in the sense that, in addition to the sequential and impact test, a need, qualitative and or quantitative, for the retail floor space to be granted planning permission or sought was a policy requirement. That remained policy in England until December 2009, when the former PPS Planning Policy Statement 6 was replaced by PPS 4.
Yeah.
And need, in terms of a requirement to demonstrate such in support of proposals for edge-of-centre and out-of-centre retail development, has not been part of national planning policy at any time since. And by way of a recital of the history, it's dealt with in my Lord the Senior President's judgment in the Warner retail case.
Where is it?
2016 EWCA Civ.
Sorry, just give me the reference again.
2016
Yeah.
EWCA Civ 606, paragraph 8. And that authority isn't before the court. I don't think any of the parties think that in substantive terms it is relevant.
No.
But it does recite the history of the evolution of planning policy in that respect.
Okay, thank you.
Point number 1. Point number 2, short heading is this, paragraph 87 of the MPPF 2021 interpretation and application. The focus of the submissions, and indeed this appeal, has been on that part of paragraph 87 that requires, in the context of an out-of-centre or edge-of-centre retail proposal, examination of potentially sequentially preferable sites that are suitable and available. I respectfully adopt and place some emphasis on Mr. Carter's 5th point before lunch, and that point essentially was that the words suitable and available are entirely straightforward terms, are well understood, and they are required to and are applied by local planning authorities and inspectors regularly to a wide range of circumstances. And the application of those tests, suitability and availability, is of course a matter of judgment, and may, and I'll come back to this in a moment, but may, in an individual case, require particular examination and interrogation by the local planning authority. But be that as it may, in my submission, endorsing the submission made by Mr. Carter, that a court should be slow in an interpretative exercise to elaborate on the meaning of, or to supplement the language used in the context of what otherwise would be entirely straightforward policy terms. And that, in my submission, is what the appellant is seeking to do through this appeal. And the court, in my submission, in the context of paragraph 87, should be particularly cautious before acceding to that invitation in circumstances where the government, of course, have not seen fit, in the context of the sequential test, as far as town centre uses is concerned, to elaborate, expand upon, or to otherwise explain in the PPG the meaning of those two entirely straightforward terms, suitable and available. And indeed, the court, goes without saying really, that this court, and indeed courts at all levels, have on many occasions cautioned against over-elaboration of what otherwise are straightforward terms, particularly in the context of planning policy, which is intended to be applied widely to a range of circumstances and straightforwardly by a number of stakeholders and other persons interested in the planning system. Thirdly, Mr. Turney, on behalf of the appellant's formulation, early in his submissions, Mr. Turney formulated the issue before the court as being whether a site which is available for a type of retail use proposed, or the type of retail use proposed, but is not available to the applicant for planning permission, is available for planning policy relating to the sequential test. That was essentially the gist of what was being put. Now, I might have formulated it slightly differently, but I understand the gist of the point. And that was essentially, if there is a site that is suitable, if it's not actually in the control of an applicant for planning permission, does that mean that it's not available for the purposes of the sequential test? In my submission, the answer is it depends. And it requires, in the circumstances of an individual case, an interrogation as to why the site is not available or in the control so as to be available to an applicant for planning permission. And that is a classic application of the test of availability applied entirely straightforwardly. By way of illustration, there are three scenarios that I've put before the court to explain how this, in my submission, works in a range of circumstances. Firstly, it may be that there is a suitable, sequentially preferable site, but it is held by another party or individual who is not prepared to release that site for retail development of the form sought by an applicant for planning permission. It may well be that that individual who holds the site is either land banking the site, holding on to it for the future with a view to increasing its value, or alternatively, that landowner may wish to seek to develop that site for his own purposes. Indeed, that is close to the facts in this case, where you have a site in the town centre or on the edge of centre that is held by a landowner, circumstances where it's been taken up by a rival retailer and therefore is not available to be taken up by the individual for whom planning permission is being sought. Now, in my submission, there is nothing objectionable as a matter of judgment, nothing objectionable in my submission about a local planning authority determining that in those circumstances, the site, the sequentially preferable site, is not available to the party seeking planning permission for an edge of centre or out of centre development. And that is a classic example of the straightforward application of the term available. At the other end, or towards the other end of the scale, there may be circumstances.
This is your second scenario?
Second scenario, my lord. At the other end of the scale, or towards the other end of the scale, there may be a site in a town centre which is entirely suitable, which is on the market for retail development, but the price cannot be agreed, either because the landowner of that site is asking for too much, or the retailer seeking planning permission for an edge or out of centre development is not prepared to pay that amount. Now, in those circumstances, it may well be that in the application of the sequential test and that part of the test concerning availability, the local planning authority form the view that the site is available. Whether or not they form that view is a matter of judgment, and in an individual case, it may require the local authority to seek further details, further particulars about the price offered, and seek objective guidance on what is a reasonable price. Again, that's another example of the application of the straightforward test of availability. The third scenario comes back to a scenario that was put by Lord Justice Lewis during the course of Mr. Turney's submissions. That's the Aldi two sites scenario, where you have Aldi, who has control of and available to it a site in the town centre, but is also seeking permission for a site outside the town centre, whether on the edge or fully outside. Now, the extent to which, in support of its application for the edge or out of centre site, Aldi can demonstrate that the town centre, well, there's no other site available to it, including its own town centre site, requires consideration of what Aldi's intentions are. And if the local planning authority are satisfied that Aldi genuinely in that scenario, consider that there is capacity for 2 new food stores, one in the centre on the site it controls, and one on the edge or out of centre for which it's seeking planning permission, then the local planning authority could perfectly reasonably, in those circumstances, conclude that there is no sequentially preferable site available to Aldi for the development for which it seeks planning permission. Now, I appreciate, and for the reasons given by Mr. Carter before lunch, in those circumstances, a local planning authority may well be cautious before accepting at face value a case being put by Aldi in those circumstances, but it is well within the scope of the powers and practice of a local planning authority when considering an application for planning permission to interrogate the position fully to ensure that Aldi's stated intention is genuine. And as the court will have seen from the background information in this case, it is far from uncommon for local planning authorities to engage external agents, experts in retail planning, to advise them on the evidential basis for the sequential test and how it's been applied, and indeed the impact test. And again, as Mr. Carter submitted before lunch, and I respectfully adopt those submissions, a local planning authority has available to it in that situation a range of powers in terms of the imposition of planning conditions or the requirement for planning obligations to ensure, for example, and if it was considered necessary and reasonable, that in the Aldi scenario, the town centre site is opened and operational, and indeed remains operational for a period of time before planning permission for the out or edge of centre site is implemented and itself made operational. So in my submission, all that goes to demonstrate that that element of the sequential test that relates to availability is a straightforward term and is capable of being applied in a range of circumstances. I make 2 final points on this third issue. First of all, I do not accept, and in my submission it's not correct to say, that in all cases the application of the sequential test, whether going to suitability or indeed availability, has to be carried out blind to the identity of the particular applicant for planning permission or operator. And the Aldi 2-site scenario is a clear example as to where, in a given set of circumstances, the identity of a particular applicant or operator does become relevant. So in my submission, it's going too far to rule out in all circumstances that identity is not relevant for the purposes of the application of the test. And there is nothing whatsoever in the language used in paragraph 87 of the 2021 framework to indicate that that proviso is necessary. And secondly, if and insofar as it was part of the submissions for the appellant this morning, that where you have circumstances where there is a suitable town centre site and a suitable edge of centre site, that essentially the town centre site needs to be developed first before planning permission can be granted for the edge of centre site. That, in my submission, is introducing into paragraph 87 a further temporal element to the sequential test, in the sense that you need to exhaust all town centre opportunities before you even contemplate granting planning permission for edge or out of centre opportunities. There is nothing of that sort in paragraph 87. And if, in a particular scenario, it has been demonstrated in the context of an application for either an edge of centre or out of centre site that there are no suitable or available town centre sites, then the fact that there is a town centre site, albeit one that is not available, does not mean that planning permission should not be granted if those tests are met for the edge or out of centre development. So it's effectively, it's like having 2 glasses. one glass was the town centre, one glass is edge of outer centre. You don't need to fill up the town centre glass before you start pouring water into the edge of centre glass, if the policy tests are met. So, my Lord, those are my submissions by way of response to Mr. Twilley's formulation. Point number 4, Aldergate. The appellant's case, indeed, and its appeal rests very substantially on Aldergate. And what the appellant essentially says is that in Aldergate, Mr. Justice Ouseley held, as a matter of law, that in engaging with and applying the sequential test, you cannot have regard to the particular circumstances of an individual retailer. That's essentially the nub of it. In my submission, that is incorrect for a number of reasons. Firstly, before we get into Aldergate, there's nothing of that sort within the language either expressly or inferentially in paragraph 87. Secondly, Aldergate was concerned in particular with the question of suitability of potentially sequentially preferable sites in a town centre. And no less importantly, Aldergate, insofar as it considers that issue, was based upon very particular facts. And those are the facts that are set out in paragraphs 34 to 49 of the judgment. And in my submission, the most relevant paragraph is paragraph 38, that really encapsulates what the underlying factual context of the dispute and therefore the judgment in Aldergate was. And that essentially is that in considering in the application of the sequential test the suitability of town centre sites, the requirements or preferences of an individual retailer's trading style, commercial attitude, preferences, site preferences, commercial preferences, should not dictate what sites are suitable and available. And that was, as the court will recognise, in the context of a range of potentially sequentially preferable town centre sites being excluded from the exercise because the operator, Aldi, said to the local planning authority, we would not trade from those sites because it would put the new store in direct competition with one of our existing stores and a store for which we've got planning permission. Now, that is a very particular set of facts in my submission, and properly considered, what the court was doing and deciding in Aldergate is that that sort of factor is not material in determining the parameters of suitability for the application of the sequential test. And in my submission, the approach that was taken by the court in the series of paragraphs that all parties have identified as relevant has to be considered in the context of that particular issue that was under examination.
Yeah. Just to be clear, you've adopted the submissions made by Mr. Carter without qualification, I think.
Yes.
Does that mean that you've adopted the submission he made about paragraph 42 of Aldergate? Which he said was wrong.
Yes, my Lord.
In part, he said. The third and fourth paragraph.
Yes, I mean, it was the sentence beginning at the very end of paragraph 56. Page 56, I'm sorry,
In
page
fairness,
56.
I think Mr. Cobb said if necessary. He would say it was wrong.
Yes, he did.
Yeah.
Quite
I
right.
mean, the way I would put that point, my Lord, and if this does depart from anything Mr. Carter said, then forgive me for sort of moving the goalposts on this. If what the judge was saying in paragraph 46 is essentially...
42.
Paragraph 42 on page 56
Yeah.
over to page 57
Right.
is essentially that you cannot have regard in terms of looking at suitability or availability, the practical realities of the situation, and in particular, in terms of whether a site is available to another retailer, have regard to the fact that the site is already taken up by a rival retailer. If that's what the judge is saying, then I respectfully do say that goes too far and is wrong.
But that's really the same as what Mr. Carter said, I think,
Yeah.
to be fair.
Yeah. But in that case, I would adopt the same approach. But in my submission, that is really taking that paragraph A out of context and putting it too high. Because that paragraph and the series of paragraphs of which it is part is looking at the question of the application of suitability and availability in a particular factual context. In my submission, it is not and should not be taken as being elevated to a point of interpretative principle in terms of what the correct legal parameters are for the application of suitability and availability in all cases. And if that point, my Lord, needs endorsement in terms of an overall approach, and I just remind the court, as I did in the court below, of paragraph 48 of Mr. Justice Ousley's judgment in Aldergate, page 58 of the bundle. If I could just ask the court just to reread the last 6 lines, a sentence beginning with the true focus of the interpretative debate.
Yes.
And that is, in my submission, a well-made and salutary warning. And considered in the context of the period series of paragraphs of which this is the penultimate in terms of those that are relevant, to elevate what this judge was saying, Mr. Justice Ousley was saying, as being a point of, in principle, policy interpretation, as opposed to being considered in the lens of the facts in that case, is doing precisely what the judge was ruling against. Well, Lord, the last point is a point of substantive correction to my skeleton argument, if I can deal with that very briefly.
Okay. Right, let's just get that in front of us.
Paragraph 16 of my skeleton on page 3.
Yeah.
I refer to Aldergate in paragraph 16, and in particular effectively the factual basis of Aldergate. And in the second sentence, the submission is this: the sequential assessment in that case excluded a sequentially preferable town centre site which was proximate to existing and operational Aldi stores. In fact, Lords, there was one existing and operational Aldi store in Aldergate and another store that had been granted planning permission, but certainly so far as the judgment is concerned and the recital of the facts has not yet become operational. I refer the court, by way of a side note, alongside that correction, to paragraph 4 in Mr. Justice Ousley's judgment in Aldergate that sets out the correct factual position. I should say nothing changes in terms of the submissions that I then make on the basis of Aldergate in the skeleton, but that factual point requires correction.
Right, well, we've made that correction.
Unless I can be of any further assistance, my Lords, those are my submissions.
Okay. Thank you very much. Yes, Mr. Turner.
My Lords, I'll deal firstly with the suggestion that my interpretation involves some sort of gloss or paraphrase on the meaning of the relevant policy. Obviously, I don't accept that, and my submission is that the word available necessarily begs the question, available for what or available to whom? And that's the point of interpretation that we're trying to ascertain. And to do that, we need to find an answer. And it's not putting a gloss on a word to try and find what it is referring to. And in my submission, such an approach is entirely consistent with Tesco and Dundee. I mentioned paragraph 21 of Lord Reed's judgment, which is tab 1, page 12 of the authorities manual, where he says if a provision in the development plan requires an assessment of whether a site is, quote, suitable for a particular purpose, calls for judgment in its application, but the question whether such a provision is concerned with suitability for one purpose or another is not a question of planning judgment. It is a question of textual interpretation. And the same, I say, applies here. Mr. Carter took, to some extent, issue with my characterisation of the question to the court, but to reframe it to address his criticism of the overuse of the word available, it could be reframed as, does available here mean A, available for the type of retail use proposed, or B, available to the applicant for planning permission? Because it is completely clear that the defendant's approach and the judge's approach below was to go for B, available to the applicant for planning permission. And I say that the proper question is available for the type of retail use proposed. And that submission is entirely consistent with paragraph 35 of Aldgate, where Mr. Justice Ouseley says that in terms. And although both my learned friends sound caution on paragraph 42 of Aldgate, I'd remind the court that paragraph 35 of Aldgate contains the reasoning which is followed through at 42. The judge says, in my judgment, suitable and available generally means suitable and available for the broad type of development which is proposed in the application by approximate size, type and range of goods. This incorporates the requirement for flexibility and excludes generally the identity or personal corporate attitudes of the individual retailer. So that's the interpretive finding about suitable and available. And I say nobody before this court suggests that is wrong. On the meaning of the words, Mr. Edwards gives a series of examples. I'll deal briefly with these, and it's effectively the first one is about an owner who refuses to release the land for retail development. But Mr. Edwards went on to say, but that might be because they have already agreed that it will be developed by another retailer. In my submission, such a site is plainly available for the use proposed. Obviously it is.
On the use proposed, I mean, if you look at the word of the policy, it says if suitable sites are not available, it's describing a state of affairs for the site. The site has to be available.
Yes.
And expected to become available. If it's for planning use, it's harder to, I'm not saying it's impossible, but it's harder to expect those, to think of those words as expected to become available for planning use. It's much more natural to read it as expected to become available, i.e. get onto the market within a reasonable period, isn't it? Because what would a time period be doing for, if it means available for use? I haven't put that well, but you can see what I'm getting at.
Well, my lord, it's available. Well, the reason it could become available for the use is the good example would be the existing retail store where the occupier is in receivership, for example. It might not be available for the proposed use today, but by the time that the retailer has gone bust, it will be available for that use because it will be vacated. Or the next store at unit 4B. We know that Next are winding down operations. It's not available today because Next are still in there selling clothes. But in a matter of months it will be available because Next will move out. So it's available for the use proposed. It's available for the food retail use. On the two sites example, in my submission, it is the effect of the sequential test that one would be required to grant for one and refuse for the other. That is the effect of the sequential test. Now, when my learned friends say, well, you deal with it by planning obligation, such a planning obligation would be unnecessary if the town centre site was to be regarded as unavailable in those circumstances. There would be no case for imposing a planning obligation. You simply say it's unavailable, and therefore the sequential test for the out-of-centre site is passed. The next point is Mr. Edwards' submission, where he says that, and I think this is a sort of standing back and looking at the effect of provisions, he says that it is not necessary to fill the town centre glass before you fill the out-of-centre glass. In my submission, that's wrong. The thrust of the policy is precisely the opposite of that. Town centre first. You should take up all possible opportunities within the town centre before you look to out-of-centre locations. And that's captured in the words in paragraph 87, and only if suitable sites are not available or expected to be available, should out-of-centre sites be considered. So you fill up your town centre first. Mr. Carter then, in his submissions, addressed the question of planning judgment and the evaluation that has to be made by a planning authority. And in response to that, I make two submissions. One of them is that at page 60, of the bundle, and in the conclusions in the, this is the supplementary bundle, tab 3, page 60, conclusions on sequential approach. And the third paragraph under that heading, what is considered to be very important in this case is that the issue here is availability, not use. The Aldergate judgment clearly states the identity of the applicant is not relevant to the scope of the sequential test, and the issue is whether other sequentially preferable sites are available for the type of retail use proposed. But then, in this case, as Unit 4B have been taken up by other operators, they are not available for the type of retail use for which permission is sought. Now, there is no broader judgment being made there. There's no evaluation here of the stage at which these negotiations have reached or anything like that. It is a binary. Water Street is earmarked for Aldi, Unit 4B for M&S or another retailer. They've been earmarked by a particular retailer, and therefore, says the officer, they are not available.
That's the conclusions. I mean, to be fair, if you look at the previous page, land at the water site, bottom, given that an agreement at an advanced stage, the very word advanced suggests that somebody's turned their mind to it. Is this just inquiries, or are they into deep legals here?
My Lord, maybe, and perhaps that also goes then to the next point that Mr. Carter makes about planning judgment, where he says that the difficulties with the test I postulate are exposed by the exchanges we had in my submissions about the point at which a site becomes unavailable when it's taken up. Well, exactly the same difficulties, well, not exactly the same, a comparable set of difficulties would arise on the construction favoured by the defendant. Because you'd have to ask in any given case, well, is this available to this retailer? Well, what if Aldi doesn't pursue their contract with Moorbane for Unit 4B? What if you had a scenario where Aldi and Lidl were both bidding on the same site and it was unclear who would succeed in that? What if both parties were, quote, in legals? So the difficulties of application apply in any case, but those are matters of application. What I say here is that there's been a misinterpretation. My Lords, the next point by way of reply is on Mead and Mr. Carter's submissions on that. Of course, I appreciate a different issue arose there, but I don't accept that Mr. Carter is assisted by the word available having a broad meaning, because the broader the meaning of available, the more sites will be available. And this is, I think, the way to encapsulate it, that if the word available in the flood risk sequential test includes a site owned by another person with permission for that use, then I say that the word available in the retail sequential test also includes a site owned by another person with permission for that use. And of course it was the appellant's submission in Mead that the PPG had altered the MPPF by including in the word available a site owned by another with permission for that use. And that proposition was the one that was rejected. And there's nothing in Mead that my learned friends say needs to be revisited. And if I can just take this as a practical example, if we were to imagine that the application site here was also in flood zone 3, the effect of the MPPF as they see it is there would be a sequentially preferable site under the flood risk sequential test, because the Water Street site would be available, it being owned by a rival and with a proposal for that use. But for the retail sequential test, it would not be available. And in my submission, that exposes the problem with the analysis, available in my submission clearly must mean the same thing in the flood risk sequential test as it does in the retail sequential test. As to the absence of PPG here, that doesn't cut across available having a broad meaning. The fact that the Secretary of State has not further defined it in my submission supports my proposition that it means available for retail use proposed, not available to the retailer in question. The next point is Mr. Carter's broad submission that at no point did the local planning authority take into account the applicant's identity. Well, in my submission, that's wrong. They did take into account the applicant's identity because it was not Aldi. So one feature of this applicant's identity was that it was not Aldi and it was not Marks and Spencer. And that was important and in fact determinative of the question of the availability of those other sites.
Well, they said they're not available to Lidl in this case, or in fact to anyone else.
Well, they were available to Aldi. It was available to Aldi. And my Lord, I contest the logic of that. If this was an application just by the landowner, not without any retailer on board for the same use, then the answer would be, well, this development would go to Water Street because Aldi have advanced plans for Water Street.
So you read those words as meaning not available to Lidl in this case, or in fact to anyone else except supply the words Aldi and ultimately Marks and Spencer on the other side.
It clearly was available to somebody. It was available to the rival. And that was the point. So the fact that this was an application by Lidl was in fact determinative of the outcome of the test. If it had been an application without a named operator or an application by Aldi, it would have failed the sequential test. And although Mr. Carter explored the question of Aldi as the applicant, he didn't actually tell the court what his position was on this. But as I understand it, his position is that Aldi, if the application had come in for Aldi, it would have been found to fail the sequential test on the basis of an available site. That's how I understand his submission. Now, if that's right, then this application has been determined on one basis for Lidl and on a different basis, and would have been determined on a different basis for another applicant. And if it's wrong, then it's very difficult to see how that reasoning would have applied, despite the fact that Aldi had a working relationship and negotiations with Moorbane for a sequentially preferable site, that they should nonetheless be granted planning permission for the out-of-centre site. That would make a nonsense of the test altogether. And that's why I say this is the heart of it. And although one can see the difficulties that are faced, and it is difficult, this is a hard case. This is a case where Lidl shouldn't have received their grant of planning permission because Aldi had a sequentially preferable site, at least to some extent, banked. And I'd emphasise here that, of course, it was Aldi's position on this application that their site was sequentially preferable. We see that in the officer's report, pages 18 and 19. They were absolutely clear that their site was sequentially preferable, and as such, the Lidl application should be refused. They weren't arguing that their site was not available. They were saying, no, it is. It's sequentially preferable. You should refuse this, and no doubt in the context
Is that in the, where is that set out? That's in the...
Page 18 of the officer's report.
Thank you. Thank you.
It's the bottom of page 18 and into 19. Under the heading further objections on behalf of Aldi on retail policy grounds.
Thank you.
And it's the middle of page 19, or second paragraph in 19. For the reasons outlined, it remains the case the only logical conclusion the local planning authority can reach is that land at Water Street is sequentially preferable, which was precisely the point Tesco were putting as well. My Lords, the final submission I make is this. if my learned friends are right, then the question I say that arises is where does Aldergate stand altogether? Because I've already shown the court paragraph 35 where Mr. Justice Ousley sets up the point generally. When we get to paragraph 42, whilst obviously my learned friends are slow to say Mr. Justice Ousley has got it wrong, they have to say that for their case to succeed. Because the example he gives is precisely this kind of case. So there's no question of if he was saying that or if he was meaning something else. He says in terms, a town centre site may be owned by a retailer already, well, or under contract, we just need to substitute, to use itself for retailing, who's not going to make it available to the other. That describes Water Street. It is plainly available for retailing, though only to one retailer. That does not mean that another retailer can thus satisfy the sequential test. It's plain what he's saying. So the idea that if it's necessary, they would say it's wrong. They do say it's wrong. The problem, as I say, is that that unpicks, working backwards, every step of reasoning from paragraph 35 onwards. And I say each of those steps is correct in law. And the only further point I put on Aldergate is again just going back to paragraph 36. And Mr. Carter accepted the correctness of the proposition in paragraph 36 about the relationship with the development plan and the plan making stage. But again, if we're to test that on the facts of this case, Mr. Carter's submission is that in identifying locations for retail development in Stockport Council would be obliged to find that the site proposed by Aldi for that precise form of development was not available for that development. Because he says available means the same in both tests. Or, because he didn't quite touch on the point, perhaps Mr. Carter says they'd be bound to say it was available, in which case it's available for plan-making purposes, but not available for decision-making purposes. And again, I say that can't be right. My Lord, those are my submissions. There's one point I wanted to raise about the note. About
Oh yes, and let's
plan.
just check whether there are any questions for you on your reply.
I don't think so, thank you.
Yeah, fine, so the practical point.
We on this side of the room are in the course of preparing a table or similar that sets out the details of all the sites and plots them on a plan.
Mm-hmm.
And obviously we'll agree that with the other side before we submit it. Is there a particular time frame to do that in? I suspect it might not be today because there's
No, that's understood. End of the week. End of the week. Friday close of play.
Thank you very much.
Thank you very much. I think that's reasonable. If there are difficulties unforeseen at the moment, just let us know. But otherwise, close of play on Friday, please. All right. Right. Well, implicit in what I've just said is that we are reserving judgment. Judgment will be provided in draft in due course in the normal way. At that stage, please, corrections to the draft on factual matters, minor factual matters and typographical or textual matters only, please, not on the substance of the judgment at all. Any submissions, please, on the draft order to be accompany that draft order as submitted at the time of the corrections on the draft judgment. Normal embargo arrangements will apply. They are not merely for show, they have real consequences if disobeyed. Please heed them. The consequences will follow if they are not abided by. I hope that's clear. I think I've left anything else out. Thank you very much, all of you, for your submissions.
All rise in favour.